And today I'll be giving a short webinar on terminating a commercial lease. And this is specific to the state of California. Just keep that in mind if you're somewhere out of state watching this. This may not be consistent with the laws of your state. So what I'm going to go over today in the presentation is general considerations to keep in mind when terminating a commercial lease, different ways that the parties can terminate a lease voluntarily, different ways that it can be terminated non-voluntarily, some of the things that the parties should consider after the lease has been terminated, and then I'll have a short question and answer section at the end. And as I mentioned, I'm Stephen Blake. Our law firm specializes in real estate litigation and real estate transactions. We do a lot of work for commercial property owners, landlords, property managers, commercial tenants. So we've been dealing with this issue very frequently over the last year since COVID came in place, and a lot of commercial leases have gone into default and people have closed their businesses. So this has been very relevant over the last year. Some of the general considerations that the parties should consider, and when I say parties, I'm typically talking about the landlord and the tenant, the parties to the commercial lease, is what does the lease itself say about termination? You want to make sure you understand what the provisions say, if there was any amendments to the lease that talk about different reasons to terminate. For example, over the last year, a lot of people have had questions about whether or not COVID has given them an excuse to terminate the lease. And to be honest, it depends on what the lease agreement itself says. And in the commercial lease world, the type of lease can vary greatly. I've seen commercial leases that are 3-4 pages long, and I've seen others that are 200 pages long. It really just depends. And then sometimes too, you're going to want to make sure that you have all the other communications between the parties regarding the lease and any rights to terminate. And you know, it could come up in a number of different ways, but I was thinking of, let's say you sign a commercial lease and you're in the premises for a couple of years, and all of a sudden there's a huge beehive outside your premises and you keep getting bees inside the business. And let's say the landlord sends the tenant an email and says, hey, if these bees ever become a problem, you know, I'll let you out of your lease. That could be binding. And let's say that the bees do become a problem, that email may give you grounds to terminate the lease. And lastly, something that needs to be considered is like, what was the course of conduct of the parties over the term of the lease? Maybe there's things that the parties have done or failed to do under the lease that could potentially give rise to a grounds to terminate the lease at this point. And then another general consideration to think about is, what type of property is it? Is it an office building? Is it a warehouse? Is it a restaurant? Some of those things will make a difference in what the termination of a lease will look like. Oftentimes, you know, if it's an office tenant, it may be, you know, moving a few desks out of the premises and picking up some personal property. If it's a long-time restaurant, there may be a ton of equipment in the property or improvements that were made that need to be handled. So something to consider is, what type of property is it? Or if it's an industrial property, potentially there could be hazardous waste that needs to be removed, or other considerations along those lines. Some of the ways that the parties can voluntarily terminate a lease is, the simplest one is, it's just the end of the lease term. You have a 1-year lease and the lease term ends, your lease is terminated. And what happens in the state of California is, if you stay over the 1 year without signing a renewal or a new lease, your existing lease just remains in place and it converts to a month-to-month lease. So if the lease term ends, the lease is terminated, and you know, if both parties want to split ways at that time, they can, with typically, you know, no obligations to one another. Another way is the death of a tenant. And in the commercial lease context, this doesn't come up as much because typically the tenant is a business, you know, LLC or a corporation. But if the tenant was an individual business tenant, say John Doe, and they died, arguably that lease has been terminated because there is no longer a tenant, the contracting party has died, so that lease is done, unless there's some assignment in the lease that gives rights to another person. Another way is the destruction of the premises. And this is typically spelled out in the lease agreement itself, but it'll talk about what happens in the event the premises is destroyed. And the definition of destroyed can mean different things. It can mean complete destruction, or could mean 50% destruction. So it's important to look at the lease agreement. But oftentimes, if it has been destroyed, let's say from a tornado or a earthquake, that can give rise to the parties to terminate the lease without additional penalties. Another way is government regulation. And what I meant by this is, let's say you have a industrial building in a certain area of town, and all of a sudden the city or the county comes in and they change the zoning of that area of town, and the business that you're operating is no longer allowed there, and for whatever reason it's not grandfathered in. That may give rise to allowing you to terminate the lease between the parties because of the fact that you're unable to do your business there. Another type of government regulation is an eminent domain proceeding, where the government is actually taking the land from the property owner under eminent domain. And this would generally give rise to a lease termination because obviously there's no property to lease out anymore. And then lastly is the mutual agreement of the parties. And what I mean by this is just, sometimes let's say you have a 5-year lease and you're halfway through the lease and it's not working out for whatever reason. You're not in default of anything, but you don't want to go forward with the lease. Sometimes the landlord's okay with that. They may have other prospective tenants that are interested in the spot, so they're willing to just sign a lease termination and both parties move on. So in the voluntary termination context, there's a number of different things you can do. From a legal perspective, the important thing is to get it in writing. If you are going to terminate the lease prior to the end of the term, get it in writing, make sure everybody understands what their rights are under that termination. So the other way to terminate a lease is involuntary. And this is typically when one of the parties defaults under the lease. And generally speaking, it's the tenant that would default, not the landlord, but there are scenarios where the landlord can be in default under the lease. But first and foremost is an abandonment or a surrender of the property. And this is an action by the tenant, and it happens more often than you'd think, where a tenant has possession of commercial property and they literally, one day they're just gone and they're not at the property anymore and they haven't given any notice to the landlord. That would be an abandonment of the property. And under an abandonment scenario, the landlord can take action to terminate the lease without the tenant agreeing to anything. They're just gone. Typically what happens is a notice is served on the premises, and then after a certain period of time, the lease is deemed terminated and possession is restored to the landlord. And then also along those lines is a surrender of the premises. And a surrender is a little bit different than abandonment, because surrender is where you're kind of giving the keys back to the landlord, even though there's still time left on the term of your lease, but you just give the keys back and say, I'm out, I'm walking away. And the landlord has various remedies in that situation as too, but generally that amounts to a termination of the lease. And then probably the most common way that a lease gets terminated involuntarily is in the default of rent. And if a tenant stops paying rent, the landlord has remedies under the California statutes, but typically in most commercial lease agreements, there's also a process that the landlord needs to follow when the tenant defaults in rent. And generally what's required is the landlord serves a notice to pay or quit on the tenant. And once that time period expires, if the tenant has not cured the default, the lease terminates. And it depends on the language you put in the notice regarding termination, but that's typically the way to terminate a lease when there's a default in rent. And then the other way here is a default in another covenant under the lease. And this is something where potentially the tenant is current on rent. There's no rent default, but let's say under their lease, they get 10 parking spots in the community parking area for their business. And every single day, the tenant has 50 cars parking there. The other tenants are complaining because there's no room for their customers. So that is a covenant under the lease that they've agreed to take 10 parking spots. So the landlord can serve a notice on the tenant, which would be a notice to perform covenant or quit. And it would give the tenant generally 30 days to stop engaging in that activity or breaching that covenant, i.e. 10 parking spots. And if they don't, then the landlord can terminate the lease and remove the tenant from the property following, obviously, the court process. And then, another thing along those lines is illegal activity on the premises. Let's say you rent out the business to a pool hall, and then you find out that, they're selling illegal drugs out of the premises. You can serve a notice to quit on that tenant and terminate the lease and get them out of there because of that illegal activity, which isn't allowed, both under the lease typically and under California law. Generally, when you terminate the lease for a default in the payment of rent, what happens is you file, if the tenant doesn't leave at that point and they're still there, you need a court order to kick them out in California. So what happens is part of that order includes an order terminating the lease, which it'll explicitly say in the judgment in an unlawful detainer case. And it'll also explicitly give you an order to return possession of the premises to the landlord. And once you have that order, that's what you give to the sheriff's office that goes and locks out the tenant. And in an unlawful detainer case, you can get damages as well, in addition to terminating the lease, but it's only for the past due rent. It's not for any other damages. Like if there was damage to the property when the tenant was there, they knocked down a wall or something, or if there's 5 years left on the lease and there's future rent, under those scenarios, you're not allowed to get those damages in the unlawful detainer court. You can get attorney's fees and court costs in the event it says so in the lease. And most commercial leases do have an attorney's fees provision. And also another court proceeding is bankruptcy. And it's important to understand, both from a landlord and a tenant's perspective, that once a bankruptcy is filed, everything freezes, and it's called an automatic stay. And so if the tenant is in default under the lease and the landlord is making efforts to get that tenant out and terminate the lease, by serving a notice or starting a court eviction case, once the bankruptcy is filed, the moment that it's filed, the landlord has to stop that activity. And the lease agreement itself, the piece of paper that's the lease, that's an asset now of the bankruptcy estate. And nobody can really do anything on that lease until the bankruptcy court says they can. And it happens quite frequently where a commercial tenant will file for bankruptcy. And depending on the type of bankruptcy, there's different actions that the landlord can take to get back possession of the property and terminate the lease. And I won't go into that for purposes of this webinar because it's pretty complicated and there's a lot of rules. It could be its own webinar, but what you just need to understand is everything freezes when the bankruptcy is filed, and the only way to go forward is to get an order from the court or some type of a relinquishment of the property or an abandonment or a rejection of the lease from the trustee. But again, that's a little bit outside the scope of this presentation. So no matter if you terminate the lease voluntarily or involuntarily through a court process, some of the things to think about that you're going to have to deal with after the tenant actually leaves is, what about any personal property at the premises? What's going to happen to that? Does the tenant want it back? Do they not want it back? Is it valuable? Is it garbage? And I gave the example before, if it's an office tenant, the personal property is probably not worth much, maybe some desks and chairs. That stuff doesn't sell for a lot in the auction world. But if it's a tenant like let's say like a brewery or something like that, which is very popular in San Diego, and they leave behind all their equipment, and that's probably worth a lot of money. And somebody may have a lien on that equipment as well. So it's important to try to figure out what's going to happen to that personal property before the tenant gives you back the keys and leaves. Because once they leave, it becomes a big burden for the landlord to deal with that stuff. And if it's valuable, there's a process under the law that requires the landlord to go through an auction. And that takes a lot of time and a lot of energy. And the landlord has better things to do with their time than to deal with all this personal property. So make sure that that property is dealt with. And then also fixtures. A fixture is different than personal property. It's something that's affixed or attached to the building, potentially was put there by the tenant, and those become part of the actual property. And there's oftentimes confusion between the landlord and the tenant as to what's a fixture and what's not. So it's always important to, before you terminate the lease, to do a walkthrough with the parties to make sure everybody's on the same page with what fixtures belong to who and what fixtures, if anything, are going to be removed. Next is handling the tenant's security deposit, which in California, you're required to return to the tenant after they vacate the premises. Sometimes, if the tenant's behind in rent and they're agreeing to vacate, the parties can come to an agreement where the landlord just gets to retain that security deposit without dispersing it to the tenant. So make sure that the security deposit is considered before terminating the lease. And then also collecting the unpaid rent or other damages. If you're going to terminate the lease and it's a mutual lease termination, or even if it's if it's a involuntary termination, the landlord or the tenant's probably not going to agree to pay any rent. But if it's in voluntary termination, if there's unpaid rent or other damages like damage to the property, again, like they moved a wall or a door and that needs to be replaced, how is that going to be handled? Who's going to pay for it? Does the landlord want the tenant to fix it, or would the landlord rather fix it themselves? So that's another consideration to think about. And with that, that's a brief overview of terminating a commercial lease in the state of California. So if anybody has any questions, please feel free to put that in the chat right now. If not, you can always email or visit our website, and I'm happy to answer any questions, or another attorney here at the office can do that. And if you also go on our website, you'll see some other articles that we've done and some other webinars on other real estate related topics. So with that being said, thank you very much for your time, and I hope everyone has a great day. Thank you. Bye.